Steve Hallbrook is with us, Second Amendment attorney and scholar. Steve, good evening to you, sir.
Always good to be on the show, Cam. How are you?
I am excellent tonight. Glad that you're with us. Saw this article in the Chronicle of Higher Education. Colleges get advice on crafting weapons policies that'll hold up in court. The National Association of College and University Attorneys, I guess, is having their annual confab. And one of the discussions there was how to write rules and regs that will strip as many people as possible of their right to keep and bear arms when they're on a college campus, right?
I thought this was from the Chronicle of Lower Education. I mean, it's like, it's incredible. You don't want violence on campus, so the only people you appeal to, the only people who abide by these rules are the ones who you would never get violence from. They try to use the excuse that, well, we have these heated arguments on university campuses. Well, you know, I was a college professor for like 10 years, and you have dialogue, you have arguments, but they're friendly. I've never once had anybody stomp out of a class or to lose their temper. And they said also, well, they're like 18 to 24 years old, that group. Well, also, that's on the younger side, that's the military group, people who are recruited into the armed forces. You don't trust them either. I mean, the whole thing is a fiasco. It's like, let's make a rule that makes it easier to commit violent acts on campuses.
Right. Yeah. And this, you're right. I mean, when Patrick O'Rourke, senior managing counsel of the University of Colorado, is going through arguments that these campuses can make, he said colleges could explain that their campuses could have heated discussions as a natural part of teaching, or that they house 18 to 24-year-olds who are prone to make poor choices with alcohol. You know, Steve, I was had the honor of speaking to the Youth Education Summit attendees Saturday night at the NRA's headquarters in Fairfax, and I brought this up. I said, you know, you guys are going to go off to college in a couple of years, and you're going to be told that you are a child. You're going to be told that there's no way you could possibly ever be an adult until you're 24, and maybe by the time you're 24, they'll have up the age to 28 or something like that. But they are going to try to keep you as juvenile as possible for as long as they can. And, you know, Steve, we've got 18-year-olds, as you say, who are serving in the military. We've got college freshmen who are driving their cars on campus, and I've not heard a lot of talk about taking their car keys away. But yet, when it comes to the exercise of a constitutional right, the right to keep their arms, this is where we get into this argument, well, these 18 to 24-year-olds, Steve, they could never, ever be responsible enough to handle a right like that.
Well, you know, it's that age group and that cut of people, those who want to pursue higher education, are probably one of the less likely groups in all of society to commit violent acts. I mean, if you want to use a percentage of people who do that, I mean, what are you going to do? Disarm poor neighborhoods? Because there's more crime there than any other place, even though that's also a place where law-abiding people probably need guns the most. And what I thought was interesting, it's like a fetish. They're interested in their gun laws being upheld or their prohibitions being upheld, instead of just being the across-the-board gun ban utopia that they always dreamed of before. They're around, so how can we just make a law or a prohibition for its own sake? They're looking to have it upheld in court. One of them himself had argued a case in the Colorado Supreme Court, and they was asked the question, well, what makes your place so special? Now, we had a case from the Virginia Supreme Court. There was a pro se challenge to a partial gun ban on George Mason University campus.
Yeah.
And, pro se means that he had a fool for a lawyer, namely himself, and he was not a lawyer. So the court held that guns could be banned from the buildings that were in use, and only as applied to students and maybe faculty, I'm not sure, but it never even arose as to banning gun possession by people who held concealed weapon permits. So that was a limited decision indeed. I mean, the grounds of George Mason University, the ban did not apply just on the grounds. It was only in the buildings. So, I mean, what are they looking for? Just a victory that they can call it a victory? I mean, what's the distinction having it inside the building, having it outside the building? If you're a guy who's going to do harm, it means anything to you.
Absolutely. And it's what's sad, Steve. I mean, ultimately, I think what's worst of all about this is here you have these attorneys getting together and talking not about ways to respect the rights of students and faculty members and employees there, but talking about ways to go after their rights and to ensure that their rights can't be exercised on a college campus. I hate to say it, but I mean, it really sounds like they want college or these universities to be, dare I say it? I mean, like totalitarian zones where your rights don't matter.
And they never, I mean, that's as a matter of constitutional right, but they never looked at the practical side. I think what brought this issue to the microscope where everybody could see was Virginia Tech.
Mm-hmm.
With all the illusions that anybody could have, or the fact that most people didn't think about it that much, here you had a rule that the students followed, the faculty followed, and look what happened. It's just not realistic. Hello, put on your, or take off your blinders, I should say. That bad people are gonna go by these rules. It's just an illusion, and so why impose that rule on everybody when look at what can happen?
Well, absolutely. Do you think, Steve, that this demonstrates some defensiveness on the part of the campuses? I mean, if they're talking about rewriting their policies to make them legally acceptable, does that not indicate that they believe right now a lot of these blanket bans can't be upheld in a court of law?
They've been shocked into the new reality that the Supreme Court has recognized, beginning with Heller and then McDonald, that, whoa, the Second Amendment means something. The right of the people to keep and bear arms. We harped on that for years, right? And what were we hearing from the lower federal courts most frequently? Well, that just applies to militia forces and only when they conscript people. And now it's clear that the Second Amendment means something. How long can we continue to ban it from college campuses? Can you imagine the uproar if the police could just come onto a college campus and search any dormitory room they wanted to without any probable cause, no warrant, no nothing? Or if you could just ban free speech on college campuses.
Yeah.
Something.
Yeah.
I mean, the whole idea that the Bill of Rights doesn't apply on college campuses is pretty phenomenal.
Absolutely. Steve, as always, sir, glad you could join us on the program tonight, and I look forward to talking to you again very soon.
My pleasure, Tim. Thank you for having me.
Always. Steve Halbrook, attorney and scholar, joining us here on Cam and Company.